Hello, everyone. Dr. Eames here. Our topic this time is federal equal employment opportunity laws and other protections that we have. Let's just start with some general observations on equal employment opportunity, the laws, and strategic human resource management. One thing's for sure, equal employment opportunity laws exist and apply in all three of the sectors, and probably more so in this course than many you take in our department. We do talk about the three sectors in human resource management because there are, in particular, some differences in how the laws are applied depending on which sector you work in. And so, in particular, we notice that there are differences for public employees. And so I'll mention those differences and the caveats associated with each law as we go along. Now, the learning objective for this time is really that you are able to recall the general framework of laws that are out there that apply in the employment sphere of activity and so forth. And no one, of course, is going to remember all the dates and the fine details. But having the foundation of what the laws are based on, the first laws, some of the historical tradition and so forth, is really what you need to be effective and be able to apply these things. So you need that deeper understanding, and you have to start at the beginning, of course. Um, we'd have to say that all organizations, whether they are a public one or a nonprofit or in the private sector, for-profit sector, you have to comply with these equal opportunity laws. They are the law of the land, and there are severe penalties if you don't follow them. Um, so there are implications for all aspects of strategic human resource management when we look at these laws and so forth, and that's what we want to take away from this. How does it affect our job as a human resource manager? And indeed, these are pillars of our society and so forth. Everybody has to work and make a living, and so these really do affect our lives. Um, and I would say, just in a general way, that public employees enjoy some constitutional protections from some of these laws that are not available in the nonprofit or the private sector. So here's an overview. And this is what I've just been saying, that you can find that these laws apply in all the sectors, and it's slightly different for some public employees and so forth. Let's talk about a little bit of history here. Uh, really, near the end of the Civil War, certainly Democrats and Republicans were arguing about a lot of things. But in particular, as the war was drawing to a close, and it was clear that the Union was going to win the war at one point there, and it wasn't always clear that that was going to happen, um, the debate began to center around the issue of how are the southern states that seceded from the U.S. Going to be treated in the future to come. And so certainly what we saw at this time was that Republicans were much more hardline about this. They, in effect, they wanted revenge. They wanted to punish the South and the leaders that were down there and so forth. And they did feel that the South and those southern states needed to be fundamentally broken down and changed into new structures and so forth. And so this really was the debate of the hour. Um, and with that thinking came the notions that former Confederacy leaders could have no political power in the future. Um, and until slavery was 100% abolished, and just because we had had the Emancipation Proclamation didn't mean that slavery had ended. In fact, slavery was still ongoing through the Civil War in places like Texas and other southern states. Um, and so this issue about slavery really, it come to the foreground. No representation whatsoever for the state until Congress was assured that slavery had been formally abolished. Um, Lincoln differed from the mainstream thinking here. He wanted a milder approach. He felt that maybe reconciliation, reunion without harsh political upheaval might be a smarter way to go. Um, and so there was a difference of opinion there. Republicans passed the Wade-Davis Act in 1864. And this was a fairly harsh measure. It was much more stringent than what the other political leaders were talking about, and indeed what Lincoln wanted. It was very stringent. It wanted an oath from every person running for office at any level, basically, that they had not supported the Confederacy. And certainly this was very vindictive, and it would have been tantamount to having no leadership in the South, really. Um, it barred Confederate officials from holding any offices in the future. And what Lincoln did was he vetoed this act, the Wade Davis Act. What a pocket veto is, there's a time limit before Congress adjourns. If a bill is sent to the president, and they can veto it or sign it. If they decide not to do either, it's what's called a pocket veto. The president hasn't signed it. The time limit expired, Congress adjourned, it therefore acted as a de facto veto, and it's called a pocket veto. Um, and then, of course, Lincoln was assassinated in 1865, shortly thereafter. So the Wade Davis Act was not enacted, but it certainly was indicative of strong political feeling, particularly on the Republican side, during this time. Now, the 13th Amendment was passed by Congress the end of January in 1865, and by the end of the year, it was ratified by the states. So it became part of the Constitution, and it formally abolished slavery. And this is the actual language for it here for you. The first two sections: neither slavery nor involuntary servitude, except as a punishment for a crime, shall exist within the United States or any place subject to that jurisdiction, and so forth. And furthermore, that Congress had the power to enforce the article and could make laws about it that spoke to this. So this was the powerful document that really abolished slavery, more than the Emancipation Proclamation, which was a statement by the president, but had no teeth in it, like this one did, because it became part of the Constitution. And so the 13th Amendment applies like the force of law to all parts of American society since this time, 1865. What we saw happen shortly thereafter was the Civil Rights Act of 1866 was passed by Congress. And President Johnson, who had taken over after the assassination of Lincoln, he vetoed the bill. And he didn't like it for a lot of reasons. But basically, the Civil Rights Act of 1866 was based on the abolishment of slavery, the 13th Amendment. And it prohibited racial discrimination in the making and enforcement of contracts and so forth, and also in hiring and promotion decisions for employment. And the act applied to nonprofit and private employers, to unions, and to employment agencies. But he vetoed it, and then Congress voted to override the veto, and so it did become law. You can see that the political divide in the country was very strong. And of course, there was a civil war going on, and certainly that's raised the temperature. The 14th Amendment came a couple years later, in the middle of 1868. And the 14th Amendment was really about citizenship and how anyone who had been a former slave or anybody who was born in the United States who went through a process of naturalization would be a citizen of the US. And so they, as a citizen, they couldn't be deprived of by any state law of their life, liberty, their property without having a legal process. And they had equal protection under the law. So these two amendments are really the cornerstone of all civil rights cases since. And today, the 14th Amendment is generally the most used amendment in all employment discrimination cases based on ethnicity and so forth. But this one really set in stone that former slaves are citizens of the United States, and they have equal protection under all the laws of the Constitution and so forth. And it did forbid the states from enacting any laws that might abrogate these rights. So The states were locked in, and the federal system was what was going to be the national law. And this direct mention of the role of the states is pretty significant because it really did mean that the states could not pass a local piece of legislation that would affect the civil rights of any group of Americans. And it is used today in more litigation. It's cited more than any other piece of law. We have a variety, a plethora really, of employment laws about equality. And in 1871, this one was based on the 14th Amendment, guaranteeing equal opportunity for all. And it basically prohibited the deprivation of your equal employment rights under any state laws. So it went further than the 14th Amendment, just mentioning the role of the states, and said the states absolutely cannot make any law specifically that will affect the equal opportunity rights of all people. So the Civil Rights Act of 1871 is certainly significant for that, and it applied to all state and all local governments. Now, the one that we talk about today the most, and which is really a big part of all of our lives, the Equal Employment Opportunity Commission and all of that stuff, all that language and the things that we hear when we talk about it, came out of the Civil Rights Act of 1964, and most specifically, the Title VII, the seventh section of this really important law. And what the Civil Rights Act of 1964 did is it prohibited discrimination, and it put very specific language in there. And this language has been modified numerous times by executive order from presidents and by other legislation as time has passed and as society has changed. But originally, it prohibited discrimination based on race, color, religion, sex, or national origin. And here's the caveats, and here's the things you need to know, the differences of how the law is applied between the different sectors. First of all, you have to have 15 or more employees, no matter which of the three sectors you work in. Now, there are limitations to this. If you're a private club, the Civil Rights Act does not apply to you. And think about what a private club really is. It is a private group, membership only. It's a get-together for whatever reason, usually social, and it is allowed to restrict its membership and so forth. And so therefore, Civil Rights Acts don't affect private clubs. They also don't affect religious organizations. And they don't affect any place of employment that is on a Indian reservation or bona fide tribal lands or anything like that. In 1972, it was expanded somewhat. It gave greater coverage to state, local governments, and educational institutions as well. This law created the Equal Employment Opportunity Commission, that's the EEOC, and this commission, this agency really does have the teeth, the weight of law behind it to investigate claims and try and resolve the disputes without going to court, but definitely advising and taking to court if necessary employers who violate the law. And there's enough evidence to say that they have done so. The only thing that exempts any real employer from these provisions of this Equal Employment Opportunity law is if you have a bona fide occupational qualification. And this is what's known as the BFOQ, bona fide qualified occupational occupation. And that means any job, it has to, the reason you're saying that someone of a certain religion or ethnicity or gender or something cannot have the job is because you must have only certain types of people doing this job, and otherwise the job doesn't work. Well, you have to really convince the federal government that that is actually the case. And what it really works out to be, and I'll talk about this later with the BFOQ, is generally religious organizations are the only ones that can qualify for a occupational qualification that exempts them from these civil rights provisions. So let's just talk quickly about the EEOC. What is it? Well, it is that agency, like I mentioned, that's charged with eliminating discrimination in employment, all phases of employment. And based on what that language was that I gave you earlier, race, color, religion, sex, national origin, disability, or age, in all terms and conditions of employment. So that means during the recruiting process, the selection, the interviewing, and actually working at some place. The EEOC does investigate discrimination through its various field offices, which are set up around the country, and they make determinations based on evidence that they gather. And they do try to reconcile the parties. But when discrimination has taken place, they will assist and direct the complainants and so forth in filing lawsuits and so forth and help them out to a certain extent. So the EEOC is that agency that oversees the compliance and enforcement activities related to equal employment opportunity in all its various forms, not just the 1964 Civil Rights Act, um, including discrimination against individuals for their age and also for their disability, if they would have one. So let's delve into the BFOQ a little bit more, the bona fide occupational qualification that says because of the certain nature of this job, we can only have certain types of people, and we're going to have to violate the law and discriminate because of that region. Well, there are two conditions that have to be met for you to be granted a BFOQ. Otherwise, it would be illegal to exclude people from the hiring process. So, the first condition is that your exception is predicated on a particular religion, sex, national origin, or age. It actually has to be an actual qualification for doing the job. And so that is a tough bar to prove that only a very narrow set of criteria apply to the person holding this job, and we can't deviate from it whatsoever. The government doesn't really look on that as fair. The second one is the exception would be based on the requirement that it's absolutely necessary to the normal operation of the employer's business, that the exception be made that the person who gets hired for this job doesn't have to meet all the regulations, that we can discriminate for some reason. And here's the reason. Well, that reason would have to meet both of these conditions here, and it generally doesn't happen. And like I said earlier, really, this is based on Title VII of the Civil Rights Act of '64. It means in your job notices and your advertisements, uh, having a worker of a particular religion, a particular sex, a particular national origin or age, it's going to be difficult for you to prove that it's absolutely necessary that one of those types of people and those only should have that job. And so they would have to meet both of those conditions and say to the government that they meet those conditions. It's an actual qualification and it's a necessary part of your operations. Um, there can never be a BFOQ approved based on race, which is really ethnicity, or color. So you can't say, we can only have a white person working here because that's all our clients are mainly white people. No, that's discrimination. So it can never be based on ethnicity or race. The word race is often used when there's only one race of humans, of course, to actually indicate ethnicities, different types of people. They're not really in different races, right? But we have that common usage out there. So let's just keep that in mind when I use the word race, and that's what's in the legality of all of it. And so what we can say and what you ought to take away from this a year from now, when you don't remember all these details, is that the BFOQ is a very narrowly constrained, very narrowly defined exception to the equal employment discrimination laws. And it's tough for any organization to meet these qualifications except for a religious organization. And that's what's important to remember. Generally, BFOQ will not be approved for any kind of organization, possibly a private club, depending on circumstances, but generally, it's going to be a religious organization. Um, Customer preferences is not considered a reasonable reason. Stereotypic notions a person might have concerning the capabilities of people of a particular gender, sex, religion, national origin do not even warrant consideration by the government here. So we're really saying this is very narrowly construed. Okay, so there are some laws as well that address religious discrimination. And so there's a lot of information to consider on this topic, but I'll boil it down to the main stuff, really. Um, it is all about reasonable accommodation. Um, if someone has a religious practice that they need to do, and it has to happen at work during the scheduled work hours, then what this is telling us is that employers have to have reasonable accommodation. They don't have to endure any undue hardships or anything, but they have to do whatever might be considered reasonable to accommodate these people. A refusal to accommodate can be justified only when the employer or the labor organization can demonstrate that if we don't accommodate them, it's going to cause, if we do accommodate them, it's going to cause us some undue hardship. And uh, and all the alternatives that you could consider to accommodate the person, each one of them would cause you undue hardship. Well, reasonable and undue hardship are pretty far apart. And so doing what seems to be a logical, reasonable thing is what the government is saying they want employers to do here. So, for instance, say a Muslim person at sunset or whatever that time of day is in the afternoon, early evening, it could be 4 o'clock. I've seen it happen a lot in many places I've worked where there were people who were Muslims working there. They got a reasonable accommodation from the employer to take 20 minutes and go say their prayers and then come back. And the accommodation was you make up that time for us somehow and we'll work it out. And that would be considered a reasonable way to handle the situation. So a religious practice and a reasonable accommodation. Um, you can't also get away with denying someone a reasonable accommodation, just assuming that, well, if I do this, then more people with that religion are going to want to come here and I'll have to accommodate all of them. And then that means I'm going to enjoy some undue hardship. That's not a reasonable argument either. So you could say that reasonable accommodation just means what would what would a normal person do to say we can work this out, and it shouldn't cost you any particular large amount of money at all, or it should be just changing scheduling and things like that. And I'll give some of these alternative arrangements. You may have more than one way that you accommodate them. Um, if they wanted to go say prayers, for example, using the same example again, then you could have them make up the time if you thought it was important. Or you could say, skip your last break, and that's equal to the same amount of time if we could work it out that way. There are always different things that you can do to accommodate people and be considered reasonable. And so the employer wants to keep an open mind here when they consider other alternatives. Um, some alternatives for accommodating people with their religious practices um, might be changing the scheduling, giving them a different job, a lateral move, something like that. But it shouldn't affect their compensation or their terms of the conditions of employment or privilege of employment or anything like that. Um, so a lot of times what you can do is find another way to make it work. If you need a certain day off for a certain thing, and it is part of your religion, and you can show that, then maybe the employer could have you swap a shift with someone, some sort of alternative arrangement, nothing too permanent. In other words, something reasonable. So a lot of times, what we see are work schedule conflicts, and these are where we can make reasonable accommodations. Employees and prospective employers most frequently request an accommodation because the religious practice does conflict some way with their work schedule. Um, the accommodations that can be thought of and come up with are not all inclusive. You can always come up with a new idea, be creative. These are all things, approaches that are considered a reasonable way to handle a situation like this. Um, and so if you can use a scheduling approach to fix the conflict, then that's great. Um, And that would be certainly an easy way for both sides to get what they want. Uh, the EEOC recommends that you do voluntary substitutes and swaps. And so pub publicize these policies regarding accommodation and so forth and voluntary substitutions within your company so that employees know that they're available. It ought to be part of your espoused values that you do value diversity of thought and practice and so forth. And certainly publicizing that, okay, we have policies that we do reasonable accommodation. Just contact your manager and let us know. You want to promote an atmosphere, in other words, that substitutions are favorably regarded and so forth. Um, and so you could do all sorts of things to make this easy for employees, provide a bulletin board where people could post notices, or it could be electronic bulletin board where people could visit and say, hey, I have something that I need to do, a religious thing I would like to do. Can someone swap a shift with me on this day at this time? Or something like that. And if you can't work it out, then you go to your boss and see if you can get some more help. We want to do things like flexible scheduling, though. When you arrive during the day and when you depart could be an easy way to make an accommodation. Your breaks, like I mentioned earlier, might be one way to do it. Make them flexible. Um, Use of your lunchtime in exchange for an early departure. Stagger the work hours if your work at the company will not suffer from staggering the work hours. I mean, people come in, uh, and this happens all the time into various offices, an hour before someone else comes in. Some people stay an hour later than others because they came in later and so forth. And have a sort of a general policy that will permit an employee to make up lost time due to the observance of a religious practice. So you can see there's a lot going on with people and religious discrimination, and certainly as an organization, you do not want to do that. It is the same in nonprofits. It is the same in educational institutions. You ought to be able to work out reasonable accommodations, scheduling, be flexible, and so forth. And if it really comes down to that, maybe you are going to have to do some maybe a job change, but it would be a lateral move with no loss of pay, maybe different hours, something like that. But you want to conform with the law, and so these are things that ways to go about it. Now, when we talk about undue hardship for the employer, we're talking about things like the cost of making an accommodation and whether or not we're violating any seniority rights that our current employees have. Those are the two big areas where an employer could say to the government, to the EEOC, that the cost is an undue hardship, or trying to accommodate them just won't work because we have a very entrenched seniority system here with many people with seniority rights. So an employer could assert undue hardship to justify a refusal to accommodate um, from their regularly scheduled duty hours or something if the employer could demonstrate that the accommodation would really hurt them on their bottom line in some way. Um, the commission itself will determine what is that minimum cost that is going to damage you. So you may come in with a preconceived idea that you'll come up with some figure and said, this is hurting us. And the EEOC might say, well, no, that's not the way we see it. Um, there's a minimal cost here. So they would start looking at and saying, no, here's where we see the cost to you. And then they would determine whether they thought that cost was an undue hardship or not. So these things are going to be worked out. The EEOC is one of those agencies that will make suggestions to you that as an employer, you have to pay attention to, right? They will determine whether or not they will accept that. And this is particularly true with seniority rights. Employees, they've been in a job a certain amount of time, then they get first choice on certain things. They do not have to give up their shift. They can't be forced to give up their shifts. There are all sorts of rules, particularly if there's a labor union involved. Um, so you can't make a reasonable accommodation that's going to affect somebody else's seniority rights and deny them those. Those people would have to agree to it. If there's a voluntary swap or substitution of hours or shift, the person would have to agree if they have seniority rights. And so that is something that's important for American workers, that we have only a certain amount of rights at work, and seniority rights do give us a little bit of a safety net, and those are something most of us don't want to give up. And so that's how an employer could show undue hardship in these two areas. This is the ADEA, the Age Discrimination in Employment Act. The only thing that exempts any employer from this is if there is a BFOQ, and so again, that's going to be hard to do. It's going to be hard to get one of those. The ADEA prohibits discrimination in employment because of age, and it covers the entire spectrum of jobs. So that means selecting people for a job retention, what you get paid, other terms and conditions of your employment are all covered by the ADEA. Um, it protects workers aged 40 and older. That's the minimum threshold that we get with this law. For the first time, the government has said, if you choose someone purely on age, and they're 40 years or older, and you choose a younger person over them only because of the age, you have discriminated against them, you violated the act. It also did other things. It removed compulsory retirement for most jobs and industries. Compulsory requirement was widespread across the country in almost all industries, and many companies would simply say, you've reached 60 years old, or you've reached 65, and it's time for you to go home. And you would be retired. Um, you would have no say in the matter. And the old adage was to give you a gold watch after 20 years and push you out the door. And of course, today and over time, people have been living longer. And so compulsory requirements, age requirements for retirement are now illegal with the ADEA. And that's a big thing, really. Now, there are some caveats to the law. And so here are the things again, depending on sector and so forth. Employers have to have 20 or more employees. They have to have if it's a union, the union has to have 25 or more members for this to kick in. It also covers all employment agencies, all federal, state, and local governments, and it covers all nonprofit organizations. So basically, any company with 20 or more employees are covered by the ADEA. So does that mean that smaller companies that only have a couple of people don't have to worry about the ADEA? Probably it does. If you tried to get hired on, say, a small laborer's job at a landscaper, a construction, a roofing firm, something like that, and they've only got 10 employees, or a plumbing outfit with 12 employees, legally, unless they had 20 employees, the ADEA would not kick in, and they could discriminate against people 40 years of age and older. But we think that what we see out there from most employers is they follow the spirit of the law, and they try not to discriminate against. And those jobs I mentioned, many of them do require a little bit of physicality. If you're a plumber or a roofer, or you work in construction and landscaping, you are going to be having to do some physical work. But as far as the law is written, it's 20 employees. And so you can see the other exceptions here, unless you can come up with a BFOQ, the ADEA is in effect, along with the 20 employee threshold. You can't violate any seniority rights or violate the insurance terms of your plans or healthcare or anything like that based on age. And you can't discharge or terminate, in other words, anybody just because of their age. It's got to have a reason. Of course, today there's a discussion about right to work. We will talk about that as we work through this information. So I'll talk about being fired for good cause as we move along. Another thing that protects workers in the workplace is this Pregnancy Discrimination Act of 1978, certainly females, but it prohibits employment discrimination practices on the basis of pregnancy or childbirth or those related medical conditions. In other words, a pregnant woman cannot be forced to take a leave of absence as long as she feels she is able to work. The employer can't say, it's time for you to go home. We're tired of you seeing you sit there being pregnant and doing your job, for whatever reason they say that. And the woman says, no, I can work. I want to do my job. I need the income. Whatever that reason is, they don't even have to explain themselves. They are protected under the law like they should be. And so pregnancy officially has to be treated as a disability, just you would by any employer And there are certain rights, of course, for disability protections and so forth, which we will also talk about. Now, states can pass additional laws. They can't abrogate this, but what they can do is make it even more generous on the female side, saying, you have to do this, you have to actually pay them, or they could set up whatever rules they want on a state basis, as long as it doesn't violate the act of the federal side. And here's where we start to talk a little bit about um, disabilities. Disability, disabled people, is protected in the workforce, and you're not supposed to be able to be denied your equal employment opportunities because of a disability. So there are a few things to talk about here. A qualified individual with a disability cannot be discriminated against in any aspect of the employment relationship. And again, that includes everything that you do, advertising for the job, interviewing people, testing them, whatever it might be, compensating them, giving benefits, promotions, all of those things. Your disability shouldn't allow you to be treated any different than anyone else. And so again, it is very much about reasonable accommodation. So here is the restriction on this one. It's an employee's restriction again. Um, the ADE, the American with Disabilities Act, 1990, of course, and then again amended, as you see here, the ADA. And this is in every syllabus that we put out here on campus, right? Because we have to really comply with this law. And the deans and administration for over a long period of time have felt that this is important information that we need to tell you, that we're in compliance with, and that we follow. So it's even in our syllabus as far as that goes, and you'll see it in mine if you want to check it out. So you want to approach all situations where someone has a disability, just like you would with a BFOQ or something like that. You have to provide a reasonable accommodation for a disabled person if they can meet the qualifications, the skills necessary to do the job, as long as it does not place an undue hardship on the employer. So this becomes often about the cost argument that I've just described. Well, take a look at some of the information I've given you here about cost. One way we sort of avoid some of the problems you might have with accommodating a disabled person is being very explicit when you put out the advertisement for a job, you do your marketing for the job and so forth, that you really put the information in there. What are the specific physical job requirements that this requires? You've got to tell people everything that the job needs you to do so that you save a lot of time, and you in effect are weeding out people who won't even apply if they realize I can't do that part of the job that you're saying is there. So that's one thing you can do right away to preempt some of these problems with disabled people later. Just say, you've got to be able to pick up a 50-pound box, move it 20 feet, and you've got to bend and lift a lot during the day. And if you can't do that all day long, or according to the job description, then you probably shouldn't apply. But the job, it has to be shown that that is required for the job. So you also, this idea of medical screening, medical history, that's illegal. Employers cannot ask anyone for their medical history or to provide some medical screening of certain type. That just doesn't happen. And so it is against the law. Whenever you see that, people asking you, have you had cancer? Do you have you had lung disease? How many children have you had? These are all things that are illegal questions in employment. And so you should be aware of that. No medical history, nothing about your genetics, anything like that. When it comes to taking a test for employment, well, certainly different jobs do require you to take this or that type of test. There are a variety of them. You have to provide some reasonable accommodation. Maybe it's just how they take the test or where they take it or the actual physical environment of it. If there's a reasonable way to set it up so a disabled person that would need a slight modification, then you do that. But let's take a look at some of these facts I've provided for you. Look at this. More than 3/4 of all reasonable accommodations that employers make for disabled people costs less than $1,000. So if you've got 20 or more employees, you've obviously can probably afford up to $1,000 to accommodate someone with a reasonable accommodation. 15% of accommodations don't cost anything at all. That might be a change of schedule, moving some physical things around. Just slightly over half, 1% over half, just cost between $1 and $500. So you can see these are not onerous costs that our employers are having to undergo. 12% do cost between $501 and $1,000, but that is by far the smallest part. And then we do see about little less than 1/4 of all reasonable accommodations cost somewhere over $1,000. So the larger the company, the federal government, the EEOC agency, in fact, would determine what they see as a undue hardship for you and what would be too much of a cost. So you have to think about it long and hard before you claim that. But you can see here, it is a stereotype, a myth that's out there that ADEA and ADA laws really force employers to spend a lot of money, and that's simply not true. Reassignment is not a failure to accommodate. In other words, if you give someone a different job, that's not failing to accommodate them, that's taking an extra step to accommodate them. And so if you have to reassign someone because of their disability, then seek a position within the employee's comfort level and their skill set. If that's not possible, you may still be able to find other ways that are reasonable. Now, Immigration Reform and Control Act, as of 1986 and then revised later in 90, here's the definition. And basically, we're just talking about the same types of things in immigration as we are in employment. You can't discriminate against immigrants, in other words. You can't discriminate in respect to hiring or firing or recruitment, or someone's referred to you for a fee based on their citizenship or their immigration status, unless the law really says it's okay to do that. Or something in the contract from a government says that's the way it has to go. So what it does, what it really does is it prohibits employers from preferring to hire temporary visa holders or undocumented workers over qualified US citizens or other protected individuals. So in other words, you can't hire someone who's an immigrant in place of a legal citizen in that sense. It doesn't mean you can't hire someone. Well, you can hire someone who's an illegal immigrant, but then again, you can run afoul of the law there too. So what it means is you can't give a regular citizen's job to an illegal immigrant. That is against the law. And so it puts a burden on the employer in the sense that if they think someone is an immigrant, not a real citizen yet, or maybe they're going through the process, then they have to do certain verifications and investigations to make sure what is the truth of this person's legal status. And so they want to see documents reviewing their identity and their employment authorization. They may be an immigrant who's not a citizen, but they may have a legal document like a green card and so forth. Now, you can't discriminate against that person with a green card either, because it says that they have a legal right to get some employment. So it is sort of a complicated law that says you can't give a job to an immigrant who doesn't have the legal standing to have that job. But some immigrants do have legal standing, and then it would be a case of, were you discriminated against because they just happen to like that ethnicity or that person, or was it something else? They had better skills and for the job than you did. But of course, this immigration stuff is all messed up. The past 4 years of our country, with all the executive orders and the anti-immigration feeling from this previous administration, has kind of destroyed our framework for dealing with immigrants, as well as this, because green cards are way down. Nobody's coming in and getting green cards. You don't see much in the way of immigration whatsoever. So much of this is a moot point, is going to have to be worked out with new executive orders and so forth, which I'm certain new administration coming in is going to have to deal with it. Civil Rights Act of 1991. This is really an expansion of the previous civil rights acts. Um, it wants to prevent unlawful discrimination and harassment in employment and so forth. It's really just a way to strengthen some of the language in the discrimination laws that we already have. It is a response by Congress to Supreme Court decisions and so forth that have sort of weakened some of the provisions of the EEOC. So that's one thing you have to be aware of in the HR profession and as a manager, that laws come and go depending on the mood of society and who's in power. And they get rewritten and they favor different groups and so forth. And so it is your job as an HR professional to keep up with what is the current status of the law and so forth. Family and Medical Leave Act of 1993. This is the FMLA that we all know about. To be quite honest, we have the worst FMLA laws of all the civilized world, of all the advanced economies and market economy systems in the world, of countries that are doing well. We've got the first, just the worst. We do have something, and we didn't even get this until the 90s. It allows an eligible employee to take up to 12 works, and this is unpaid leave. Your job is protected, so you get your job when you come back off after the 12 weeks, and your health insurance continues. What this means is that something serious has happened in your life. Maybe you've had a baby, your wife has had a baby, you need time off to take care of a sick older relative or a sick younger relative, or someone has had an injury and is in the hospital, you need to be there. In our country, we get 12 weeks and it's all unpaid. In places like France, you get months. You get months and it's at full pay and you get your job back and so forth. But when we start talking about programs like this, we get into the arguments about, are we getting too socialist, too much socialism and so forth. And it is complicated. But I will say that look how many times it's been used since 93. This is a low figure now, 100 million claims filed. And let's face it, I think we all know that things come up in our lives where we need to take care of our family and ourselves. And this is about family life work balance. And it has always been an issue in American business and so forth. And your job as an HR professional is to deal with people and keep track of them when they're out and to verify their claims and so forth. Now, states can change this. They can't remove the 12 works of unpaid, but they could pass a regulation, for instance, that says they're going to get paid. There are things they could do to make it better for workers. They just can't make it worse for workers when they pass a state law. So this is really a law that allows you to care for an adopted or foster child with the first year of placement, to care for your spouse, your child, your parent with a serious, like I've said, health condition, or something of your own where you just can't perform an essential function of your job. It also covers you for military caregiver leave and so forth, that you have to go home and actually be a caregiver. So this is an important act. I would hope into the future that we could afford to be not so parsimonious about this and give people a little more support and help them out. I think the best companies out there do better than just 12 work weeks of unpaid leave. At least you get the time off, but that many people just simply can't afford to take unpaid time off. It's not 3 or 4 months worth. How do you prove employment discrimination? Well, you have to prove that there was some sort of disparate treatment or some disparate impact. And so here we are talking about protected classes of people. Protected classes of people are just various populations. Children, minors, they're a protected class of people. Pregnant women, because we have the Pregnancy Act of 1978, is a protected class of people. Disabled people, people over 40, all of those are protected classes of people, and so forth. And so disparate treatment is when an employer treats an employee or a member of a protected class differently from someone who is not in that protected class in a similar situation. You get treated differently. Generally, you don't mean to discriminate. It's not done on purpose, but it's disparate treatment. You are getting treated differently. It's the impact that's measured that determines whether or not the government thinks you've really done some harm here. Disparate impact is when the employer's policy or their practice, which might be neutral, really on its face, it was intended to be neutral, not to harm anyone, but when it was applied, it has a negative effect on the employment opportunities of those protected class individuals. And so there is what we call the four-fifths rule that we measure out, where there's a formula for it to say, um, we're more than four-fifths of these people affected by this computation as versus the people who are not protected. If you can show the four-fifths rule happened, then you prove disparate impact, and the employer would certainly have to change their practice. Affirmative action came along, and it's also really about equal rights in the workplace. And so the words affirmative action actually were given to us by President Kennedy. And they were at the actual language in his executive order. You can see the number of it here in 1961. And he said that the purpose of this executive order is to take affirmative action to ensure that applicants are employed and that employees are treated during employment without regard to their race, creed, color, or national origin. So what this executive order was a reaffirmation of many things that had come along from the constitutional amendments and the civil rights laws. But remember, 1961 is before that landmark civil rights law of 1964. So this really setting up affirmative action was a voluntary program for organization employers to embrace. And eventually we saw it codified into law in 1964, Title VII of the 64 Civil Rights Act, and then the other ones I've been discussing along the way here. And you can see that there was another order a few years later in 1965 that further amended this. It changed the language a little bit. We don't see the word creed used very often. I'm not sure what creed is. Creed is like a belief. I'm not sure. It's a word we don't use very often. I think it's sort of disappeared from some of this language. And then, of course, it was amended again in 67 to include even more language and so forth. And right now, the definition is quite long. We've included so many more elements. And I just think this is a wonderful quote from Martin Luther King here. We must learn to live together as brothers, or we will perish together as fools. What could be more appropriate in today's political climate than a statement like that? Let's talk a little bit about the Office of Federal Contract Compliance Programming. Now, this is a large federal office, an agency. It's in the Department of Labor. And this is the agency that monitors compliance for all federal contractors. In other words, if you get a job working for the federal government in some way, it always comes with a contract. And it says, this is what you're going to do, this is what we're going to pay you, and this is what the time period is. And this is what all the conditions are. Well, this office, the OFCCP, since I have such trouble saying the name, is the one that monitors all that, like the EEOC does for employment. This is really looking at all federal contractors and saying, are they following all the employment discrimination laws and so forth? And they have fairly regular mandatory rules and all of this. They disseminate policies to organizations, and they will tell them, send us your non-discrimination policy, and we'll either approve it or tell you what you need to improve on it. So what it requires from employers in particular, though, is it's linked to affirmative action that I just talked about with Kennedy. You have to have a written affirmative action plan. In other words, do you have some placement goals in general for women to move up the corporate ladder, or for people of different minorities of ethnicities and so forth? And how are you going to are you going to implement these action-oriented programs to accomplish your goals and so forth? So it can get a little complicated and so forth, just like it is with the executive orders. Trying to remember who did what order can be complicated. For instance, I showed you the one from Kennedy, and there were two others listed there. Well, the other two both came from President Johnson, of course, who just increased and really expanded on what Kennedy had started with affirmative action and so forth. So it's all tied together in one big package. Now let's talk a little bit about affirmative action and really define what am I talking about, this notion of affirmative action. We got the executive order from President Kennedy. It says we need to take affirmative action to make sure that we don't have discrimination based on all these different factors. And so that's the basis of the whole thing. But what we don't always realize is that it's all voluntary. Um, Many public and nonprofit organizations have decided to implement voluntary affirmative action because they believe in it, just like the government does. Most of us believe in it, that we should have fairness and equality in all our hiring and so forth. I believe in affirmative action. I don't think its time is done like many people do. I think we still have plenty of places out there that need a little bit of direction on not discriminating against groups of people. Now, there is some involuntary affirmative action out there, and this actually comes out of our Civil Rights Act of 1964, one of the sections again, which says that if the court finds that the employer is intentionally engaged in some sort of unlawful employment practice, it can order some appropriate affirmative action. So it can force a company to adopt a plan and to produce a plan for approval. So it's voluntary until it's not voluntary when you violate it. The spirit of what this is about. That's really what I think it's about. So you can have a conciliation agreement where an employer acknowledges that they've done some discriminatory practices. They agree to change to meet compliance. Consent decrees are agreements between an employer and the agency. In this case, it would be the ones I've been talking about, that OFCCP, or the EEOC, if that was who they were talking about. It's a consent decree is the agreement between the employer and that agency with the approval and the enforcement of the court. So they will follow up and make sure that it has actually been done. You consented to it. Let's make sure you did. It is legally binding. And then, of course, we have court orders. The compliance agency, which would be the OFCCP, the EEOC, they take the employer to court, and the court orders remedies that might be imposed. It says, you are showing way too many cases of disparate impact. You actually are affecting people, and we want you to submit a plan on how you're going to fix it. And we want it to be action oriented, and here's your time limit. So what is the difference between equal employment opportunity and affirmative action? Well, equal employment opportunity is really just a policy of non-discrimination. Affirmative action requires employers to do something, and that's the difference. They have to analyze their workforce if the court tells them to. They have to develop plans of action to make sure that they're trying to recruit and select and train and promote people who are members of these protected populations, these protected classes, and then develop some action plans to correct areas where they've been weak in the past and where they may have discriminated against. And maybe it was disparate treatment where it was unintentional. They did some policies and they didn't intend for them to have disparate impact, but they did. Well, if you follow through and change things, then you've satisfied the government and the spirit of the law and so forth. Now, the Supreme Court has been involved in affirmative action decisions and EEOC decisions of all types. The Supreme Court has upheld the use of court-ordered affirmative action programs designed to eliminate past egregious discrimination And voluntary affirmative action plans are designed to increase the representation of women and minorities. That's what this is all about, to increase these two particular classes of protected populations, women and many protected minority classes. In fact, any minority other than Euro-American is more or less protected. And so we want to get them into jobs that are traditionally over time been segregated mainly for Euro-Americans. Now, the Supreme Court has not upheld the use of racial quotas. Quotas are illegal. The, the government will not tell you just you need so many of these employees from this ethnicity and so many from this. That's not how it works. They want you to show a plan where you're trying to find qualified people to hire to do the jobs who are members of these protected classes. You don't have to hire people who are not qualified. You have to show that you've tried to find them, though. That's what it's all about, that you've made the effort, that you've had a plan and you followed through. So hiring and promotional preferences may be permissible to redress maybe some of your past discriminatory uh, actions. Now, here is another act that you need to know about. Came a result of Executive Order 13548. This is the Rehabilitation Act of 1973. And this one here was one of our very first disability acts. As you know, the ADA and so forth is in the 90s. But this one here prohibited discrimination against anybody with a disability. And then employers should take affirmative action again, have a plan to deal with it, and make sure you're not just ignoring disabled people because you don't think they can work or do the job, but you're finding room in your employment and in your company for these disabled people who are qualified to do the job. Again, this is not about hiring people who aren't qualified or meeting some sort of imaginary quota. This is about hiring capable people who normally just get overlooked. And so they want you to make a reasonable accommodation according to this act. And that's what it was about. This is when we started getting some of that first language about reasonable accommodation and so forth. Armed forces members also have protections under the law. The Vietnam Era Veterans Readjustment Act of 74 and amended later and so forth really says that contractors are required to take an affirmative action sort of stance to employ and advance disabled veterans. And in particular, this was about veterans when it came out at the time of the Vietnam era, qualified veterans. In other words, you don't hire someone who's not qualified for the job, but if you're able to hire a Vietnam veteran in the 70s, this was a very big deal because there were tens of thousands, hundreds of thousands really, of Vietnam veterans who couldn't find work, some of whom were disabled and so forth. So it really was an update. And then you can see here in 94, updated again. You have to really pay attention to discriminating against people. And we've got some of these other acts, not quite as important as this first one here, the Uniformed Services Employment and Reemployment Rights Act. In other words, if you're called up from the National Guard and you have to just leave your regular job because you've been called up and you have to go away for a couple of months, your job is not lost. In the past, a lot of armed services members, veterans, lose their jobs, and when they got called up for National Guard duty, and their employers were just, not very empathetic with it. Today, it's against the law. You don't lose your job if you're in the National Guard and you get called up and so forth. You assume that your job is waiting for you when you get back, and there's no number of employees restriction or anything like that when it comes to these armed services protection. Okay, here's something much more recent as we get to the end of all this very lengthy information on employment laws and discriminatory laws and so forth, is the GINA, the Genetic Information Non-Discrimination Act. This is fairly recent, just 2008. And as it says here, it prohibits employers from discriminating against an employee or any applicant for a job based on genetic information. Now, you'll recall that I've said that it's illegal to ask an employee for a medical history or something like that it is just as illegal to ask them for their genetic information. And in fact, it says employers are not allowed to collect your genetic information. There may be some rare circumstance where you work for a highly specialized public agency for the government or something like that, where it might be necessary and they could establish it was a BFOQ. But those are rare circumstances. Um, and so GINA is very important. Um, Genetic information includes quite a few things. And today we're really at the very beginning of this. Just think about it. The new vaccines that have just come out to fight the pandemic, this virus, are not like the old vaccines. In the past, vaccines have taken some of the virus that they want to protect you against and actually inject it into you to create antibodies. Well, a genetic approach is different. Um, we fool the body. We inject something into us that makes our body think that we have that virus when we really don't. We've changed an RNA marker, and now the body is creating antibodies because it thinks that we have something. Well, this sort of thing is all new to us, just in the 2000s in particular. And so information about an individual's genetic tests can't be collected by any employer, and you're not required to give it up. Um, or the genetic tests of any of your family members, and you do not have to give, any employee or prospective employee does not have to give information about any disease, any disorder or condition that their family members have, or anything about their family medical history. Now, this is really important because you can't violate this as an employer. So, of course, as an HR manager, this is stuff that you stay away from. Um, and at the same time, we all want protection. Just think about it. If insurance companies had access to all our private genetic information, they could deny us coverage on the basis of all sorts of things like pre-existing conditions, or a lot of genetic information is only about what might happen or what you have a predisposition for, but we don't know for sure it's going to happen type of thing. Well, insurance companies could certainly just exclude you from coverage and all sorts of things if they had this information and acted on it. So it remains secret, and we would like it to stay that way, obviously. Now, there are some constitutional protections in the public sector that public sector employees enjoy that others do not. Um, and so they are, if you're a public sector employee, to some extent, like it says here, you're protected by a broad umbrella of laws that either prohibit a government activity or create some right for you. This really began with the Hatch Act way back in 1939. Uh, and there's a lot of history here involved. Uh, but you have expressive rights is really what we're talking about here as a public employee. You have a freedom of association, where if you have a public sector job, you work for some agency, you can't be told that you can't join a political party or political organization or anything. You have freedom to associate with who you want. You have equal protection of the law. So because you're a public employee, you can't be denied certain rights. You have privacy rights. You have due process rights. And it bans the limits on political participation, which is what we see here with the Hatch Act. In other words, you can't be forced to do political activities for your boss in a public agency who might be a political appointee. Now, in the last 4 years, we've seen a lot of abuse of this. In fact, it's like the Hatch Act never existed. And indeed, we have seen a lot of partisanship enter into public agencies of all types in our government. Anybody, you could, if you don't believe me, just go look it up online and start looking at some of the things that happened in the past 4 years, where we've brought political partisanship into agencies where people are allowed to have their own political viewpoints, but at work, you do the work of the country. You do the work of the common good. You do the work of America. You don't do the work of one party or another party or anything. And we've always had the benefit of fantastic employees in our public sector who have always believed that they don't let their political views or anything dictate how they act in public agencies and so forth. So this idea of banning political participation and so forth is really important. It's been abused a lot lately. So what we might see, and what you would have to be paying attention to as an HR professional, and probably as any business manager, is where are the laws going next? Are they going to be tightened up to prevent this sort of thing? Because many of you may want to work in the public agency and have a public sector job, and certainly this is important to you. Um, Public and nonprofit employees as well might also have some additional workplace protections, like this one here, to protect you, your political rights, that prohibit maybe some arbitrary or unfair treatment from the employer through some sort of local, state, or federal statutes. Um, Things like whistleblower protection. Well, our whistleblower protection is, let's face it, is weak in this country. Generally, if you blow the whistle, in other words, you're an employee, you see something that's very egregious, that's either seriously criminal or harmful, or it rises to the level that you just can't handle it and you've got to tell people because you feel it's the right thing to do. Well, a lot of times those whistleblowers are the ones that lose out big time. And a lot of negative things happen to them. And even though we do have a whistleblower protection law, most of the time, to be quite honest, the whistleblower is the one who loses big. So that's another big discussion. But if someone comes to you in an organization and you're the HR management and they have some whistleblower level type of information to give you, be careful that you follow all the rules, that you follow the law, that you immediately think of which procedure, which policy do we have that governs this behavior, and then get going on it and do the right thing. We have all sorts of voter protections. Some states have no time off requirements. In other words, others require employers to provide some or all employees with time off to vote. Some states have it, some don't. It's very different out there. Some, if you take time off to vote, will dock your pay in some states. In others, they'll say you have up to 2 hours to go vote. Well, if you've seen some of the lines that people have been waiting in the last general election and the one going on now in Georgia, for instance, you can see that people wait much more than 2 hours sometimes in line to vote. It's a complicated issue. So some jurisdictions, you have to know the local laws, is what I'm really getting at, might require that you as an employer let your employees know what their voting rights are and what accommodations the company actually does make. Now let's talk about right to work as I come to the end of all of this. If you see that bumper sticker and it says, I support right to work, what you're seeing is a person that says, I don't care if I get fired for any reason or no reason at all. And in fact, I don't care if I get fired and never being told the reason. Right to work is really a backwards sort of a thing. Law generally presumes you're employed at will. It's your choice to go somewhere and work, and it's the employer's choice to hire you. And unless you can prove otherwise through some written documentations or something, that's the way it should work out. And you shouldn't be fired for exercising any legal right that you have. For instance, you shouldn't be fired if you take FMLA, which we talked about earlier. You can't be fired if you have to go to National Guard duty for a month or two or something like that. If you get jury duty, you can't be fired if you have to take time off for that, and so forth. But right to work, when it's passed by a state as a local law, changes all of that. You can't still be fired for taking FMLA because that would violate federal law. So these things on the screen here are the things that you can't violate. But otherwise, right to work means right to fire. That's simply what it means. That an employer can fire you for any reason, and it's their right to do so, and they do not have to tell you why. And so the last time that right to work came up in Missouri, last election, I think a year ago, 2 years ago, it was voted down, where previously, a few years before that, it had been voted in by the citizens of Missouri. And I think part of it is the way it's worded. Of course, we all support the right to work, but you don't support right to work legislation because it means that the employer can basically can you at any time for any reason or no reason. And so it's a misnomer. You simply can't be fired for reasons that are illegal in any reason, like the ones you see here. So right to work is something that is very anti-union. It's very anti-worker. Um, I don't know what employers are afraid of, uh, treating people like they have their basic rights, but this is one of those things that gives the employers much more leverage in the workplace than the people who are working there. Okay, to sum it all up, as the HR manager, you've really got to know the basics and the foundation of the laws that are out there. And you've got to keep up with the local laws and the state laws that may have modified those in some way. You have to know what are the caveats for any given law, when do they kick in, what are the differences between the sectors, and so forth. So compliance with equal employment opportunity laws, affirmative action regulations, really is going to be a big part of any human resource management job. Um, it's going to help you see the bigger picture and use all your employees in the best way possible. And it also means that you're going to be compliant with all laws and that you're not going to violate anybody's rights and so forth. And so you have to be very much aware of those protections that are out there for different groups and so forth, and not just the specificity of the laws, but what is the spirit of the law? For instance, reasonable accommodation. That's a very broad, nebulous concept, yet it really means use some common sense, come up to a win-win situation person to person. You can do that as an employer and still get the work done. And so what you need to do as an organization and as a HR manager is that develop programs that address the laws, that keep you in compliance, um, be progressive. Think of how these laws can be made to work for you and how you can get the very best workforce using those things that are out there to you. Use your human resource management as a strategic goal, a way to further your aims and to manage your workforce. And if you pay attention to affirmative action and equal employment and so forth, you are going to encounter a much more diverse workforce as time moves on. That's where the country is headed. You'll be much better prepared to rise to those challenges as they come up. Okay, folks, that's it for this time. I'll talk to you again soon.